Hello, my true crime lovely. Wait, what? Okay, they just added this, and this is weird. Oh, it's dated August 27th. Okay. Somebody from Iowa received from the judge it was received 9/18, but it was written August 27th. Good Lord, did it get stuck in a U.S. postal pipe? Dear Judge Kraynick, I have been closely following developments in defendant Sarah Boone's case, who is accused of second-degree murder, and I find her predicament very troubling. It is evident that Sarah Boone is a difficult inmate, per your decision, has forfeited her right to counsel. It is an appropriate conclusion, for though the right to court-appointed counsel is constitutionally guaranteed, the defendant does not have a right to shop for one infinitum, oh my God, ad infinitum until she finds the right fit. There are, however, some concerns and considerations which I fear will jeopardize the defendant's right to a fair trial, which perhaps have never been raised before. We must first recognize, who is this? Oh my goodness, a nosy friend, but not on our side of the track. We must first recognize, as you are personally well aware, that no person in the state of Florida, nor in any state of these United States, is allowed to legally perform the duties of an attorney without a legal law license, for which one has to pass a bar examination. That simple fact underscores the depth of education, experience, and savvy which are necessary for an individual to represent another individual or entity. But of course, these are 21st century considerations which take into account the complicated world in which we live today and which were not on any of the founding fathers' radars. Am I sharing with you guys always? Okay, yes, I am. I'm like, oh my God. Okay, back to this. Were not on any of the founding fathers' radars when the Constitution was first drafted. Expecting a layperson to be able to competently represent themselves in 2024 and with no accommodations would be tantamount to expecting a layperson to perform medical surgery on themselves and without any access to modern tools. We would never allow such a thing under the law, let alone legally mandate that someone has forfeited their right to a doctor and must now perform surgery on themselves. I feel like that's a little extreme. Because why would you be performing surgery on yourselves? You told all your surgeons to F off? Like, I don't like that analogy. This could be considered inhumane and a violation of human rights. As such, no individual without a law license should be allowed to represent themselves ever. Individuals who have the education and accreditation, although ill-advised, are a different matter. See Robert Tellis. Not considering that we cannot simply alter the Constitution without much due process. And with this, I am not suggesting that Miss Boone be afforded yet another lawyer. Well, what are you suggesting? Get to the point. What considerations should be taken in order to properly afford her access to a fair opportunity at self-defense? If another counsel is not an option, frankly speaking, there is no other choice but to allow the defendant to have access to any and all materials necessary to aid in her defense, including a law library, a computer, limited internet access, an investigator, etc. Okay, where have you been? She had access to the law library. She had a computer, no internet access. She had an investigator. And what do we do before the internet, ma'am? Or sir, I don't even know who wrote this. The defendant must be, I'm assuming it's a woman, but we'll see. I shouldn't make that assumption. The defendant must be allowed a secured place. She was offered a secure place. She turned it down because she didn't want to be alone. And anything else they might reasonably need in order to research their case, study a defense, and properly represent themselves. These considerations should be provided for any defendant choosing their right to self-defense. This should not be seen as going above and beyond treatment of other pro se defendants. So this was Sarah's quote from the trial. Well, first the lawyer said it for jail counsel, and then Sarah repeated it in a sarcastic way.
You know, the idea that she wants unfettered access with the phone and she wants to make calls all day and night. At the end of the day, I'll also say there's case law out there that says, you know, she's gone through, I think, 8 attorneys in this case, and she has several attorneys appointed to her case, and she's kind of put herself in this position today. And the case law is not real favorable to folks that put themselves in that position.
So my understanding is that I'm being penalized by Orange County Corrections Department because of their misunderstanding in regards to my, in quotes, 8 attorneys prior. Is that why I'm unable to have anything in order for myself to properly represent myself as a pro se defendant and inmate at the Orange County
Balls
Corrections Department?
of a burglar.
I'm not going to answer that
Not
question.
being penalized, just the opposite. She's being treated like every other pro se inmate in the institution. She's not being penalized at all. She wants consideration over and above what everybody else has.
If I may please, what is over and above? What other
You're asking for more than
what is it that they've asked for? I don't see how they could successfully even represent themselves without internet and a regular working phone. They were not able to complete their case and the successful outcome that they were hoping for by being provided simply papers and pens.
It should be seen as the treatment for all pro se defendants, for to deny these things is a clear violation of human rights. And yet it's, first I just want to say, Liz Murray. Oh, Liz Murray is, I'm assuming that's a woman, concerned U.S. citizen. Oh my God. It has been argued by jailhouse counsel that none of these privileges are granted by the Constitution and that defendants should only have access to pen and paper, envelopes, and stamps. But I would venture to argue even further that the Constitution also doesn't guarantee a defendant to the right to medical treatment, meals, or even personal hygiene supplies or clothing. No, it says their punishment cannot be inhumane. It's just that we, the people, have collectively decided that human rights and the dignity of the individual matter and that they supersede any constitution or state charter. And thus it is for the betterment of all to honor them, for we might one day find ourselves at the mercy of the law and its enforcers. And if we act a fool, we deserve what we get. As long as the state is responsible for the care and housing of any inmate, pro se or not, we must also afford them a path to properly exercise their constitutional rights in 2024, not just in 1787. Oh, Lord. And where is this one from? Des Moines, Iowa. I won't put their address on screen, but goodness gracious, really? Okay. I don't know, guys. I don't know. Where are these people coming from? All right. Thanks for hanging out with me. Toodles. Talk to you guys later. Bye.